Check, check. House Committee on Science and Technology. We're going to get started in 2 minutes at 10 after 10. Ladies and gentlemen, once again, I'd like to welcome you to the House Committee on Science and Technology. To sort of set up today's meeting, I want to give a little prep. And again, I would like to thank the members for coming down today. I know you all are taking sacrifices from your schedule and from your districts to be here. I'd like to thank everybody in the audience who's being here with us, and particularly we'd like to thank our guests who I'll introduce here in a moment. This meeting really is in response to some general awareness in the public and an increasing awareness of personal information that people, whether they're consumers, whether they're people who are engaged in internet search, email, a whole number of ways where people's information becomes known and is shared, and in many cases can be sold to different commercial entities relative to people's participation on the internet. I just thought it was important to have a discussion today with real experts about what the common practices are, what the legal framework is for that, just as a part of informing our committee about where we stand in Georgia, where we stand nationally, and how that might compare even around the world to international standards of personal information privacy. So that's really just the goal today is informational, but I think it's an issue that our public really across the political spectrum is attuned to and aware of to some degree. But I think their awareness perhaps lags a little bit behind maybe where it needs to be. And with that, I appreciate your attendance today. Our guests, and our first speaker is going to be Mr. James Harvey, a partner from Alston & Bird here in town, heads up their privacy and security practice, among other things he does in his law practice, is really an expert, certainly within the Southeast, on the issue, and represents a number of corporations and private entities. Also with us is Dr. Michael Farrell. He's the co-executive director of Georgia Tech's Institute for Information Security and Privacy, really a nationally recognized expert on information privacy, blends the technology and policy disciplines as well as anybody. We're just thankful that Dr. Farrell could be with us today. So with that as a lead-in, I'd like to recognize Mr. Harvey to start us off. He's going to give us a relatively short presentation to sort of set the legal framework for the issue of personal information privacy, particularly relative to the internet. And we'll take some questions. Then we'll transition to Mr. Farrell for a short presentation and really allow much of the hearing today to be more of a give and take exchange about this in a relatively informal setting, with really the focus being let's getting down to the roots of common practices, what's being done relative to people's information in the marketplace every day, and what implications might that have for the public in ways they may or may not understand. So with that, Chair would like to recognize Mr. Harvey. Welcome.
Thanks, Chairman. I appreciate the opportunity to be here today. I'm going to try and cover privacy and security laws in Georgia, in the United States, and indeed around the globe, all in 10 or 15 minutes. So we will necessarily have to distill some of these comments, but I'll go as quickly and concisely as possible.
Mr. Harvey, if you could, for the purposes of folks who are watching this, could you pull your microphone a little closer to you?
Yes.
I think we can hear you, but I want to
Okay.
make sure people that are watching this on the
Is that
internet.
better?
Yes, sir. That's a lot better. Thank
That
you.
better?
Yes,
Okay,
sir.
great. So in the United States, all of you are used to having received notification of breaches from your insurance company, from your banks, from your credit card companies, et cetera, and these are generally driven by a number of state laws. And when you add them all up, including Guam and Puerto Rico and Washington, D.C., there are actually 53 breach notification laws. So data has been improperly authorized or accessed or on an unauthorized basis, and that requires a notice to be given to the individual. From a policy perspective, those laws really came from the place where it was important for individuals to know that their data was out there in the wild so that they could do something about it, get a credit monitoring, watch their bank statements, whatever the case may be. I think from a policy perspective, as you pull that forward several years, now people get these things so often, perhaps they don't pay as much attention to them as they used to. On a federal basis, there's also breach notification required under GLB and Hipaa. GLB is the federal law that applies in the financial services context, so when you're dealing with your bank or your insurance company. And the Hipaa is, of course, in the healthcare context, you go into a clinic or with your doctor and you sign the Hipaa disclosure form. It also has a breach notification provision in it. And you can see they cover, it's typically name plus a government-issued ID number or name plus an account number. So if those two things are in the wild or accessed by the bad guys, then there is likely a breach notification requirement. Georgia has one of these laws. The noteworthy thing about Georgia's law is that, and it works on largely the same basis as the other laws that I referenced, on name plus social, name plus a government-issued ID or an account number, et cetera. But it only applies to information brokers. The law was adopted in the aftermath of the ChoicePoint breach, which was one of the first breaches, and ChoicePoint was an information broker, and there's a statutory definition of what an information broker is. But it puts Georgia in the odd position that if a breach occurs from a technical legal perspective, residents of the state of Georgia don't receive breach notification unless the breached party is an information broker. In point of fact, most companies will go on and try and provide notice to all of their customers, even if they don't have a legal requirement, because they think it's the right thing to do. And you have people in South Carolina getting notice, or Florida, and if you don't give notice to the entire population in Georgia, people say, well, what about me? I'm a customer of a particular insurance company or something. So Georgia's law is largely cut from the same mold as the other breach notification laws, but it only applies to a certain sector of companies in the state. On a federal basis, as I mentioned, there's Hipaa, which covers health care. And Hipaa is not only a breach notification requirement, but it also governs how healthcare providers, clearinghouses, and payors can use your data. So if they're going to market to you, there are restrictions with respect to that issue, et cetera. And again, you'll see when you sign that consent, if you read the consent, you'll find out about who it is they can share your information with, et cetera. The federal government also governs the use of data through the Gramm-Leach-Bliley Act, which I mentioned in connection with breach notification, and it's largely enforced by the Federal Trade Commission at a federal level with a bit of the CFPB, the Consumer Protection Finance Bureau, and I may have messed up that acronym. And then the insurance companies are governed under GLB by the state insurance commissioners. So if there is a Georgia insurance company there are Georgia laws that apply under GLB, but generally speaking, insurance companies are regulated by the states and not by the federal government. There are a number of other sort of federal statutes that deal with the use and distribution of data. The Fair Credit Reporting Act, so we've all gone online and seen what our credit score was. That was issued by one of the credit reporting agencies, Equifax, Experian, and others. And that is a very, very heavily regulated use of data. When you apply for a job, you have to sign a consent that says, yes, you can check my credit score, and you have to be told given certain rights in connection with that process. So again, very sector specific, and there's a big contrast here. The Video Privacy Protection Act is another example. I'm not covering all the federal laws, but another example of very sector specific. It covers the rental of videos, and if you remember Supreme Court Justice Bork, or he actually was not elected to the Supreme Court, and one of the things that came up during his confirmation hearings was what videos he had watched. And that was a sort of a hyperbolic scenario, and he watched pretty, old movies. There was nothing really controversial there, but there was a bit of outrage that the fact that he watched particular videos, rented particular videos, and that came out in a public forum. So this act was passed in a very, very narrow fashion. And again, that is quite different from the GDPR. And here we have a picture of Mr. Zuckerberg, CEO of Facebook. And the GDPR is the General Data Protection Regulation. It was adopted by the EU on May 25th of 2018. It completely replaced existing privacy law, which was adopted under the EU Data Directive in the 90s. And it is a quite extensive law, and if you saw all of those things that I went through that were very sector specific in the United States, the GDPR is in fact quite different than that. It applies to all individuals, all EU residents in all contexts: healthcare, online, offline, financial services, employment relationships, credit relationships, etc. So they really regard, and I think this is not an overstatement, that they regard privacy as a fundamental human right in Europe, and this law or this regulation reflects that. And indeed, Mr. Zuckerberg and Facebook have had a number of notable issues under the GDPR and under prior privacy and security laws in Europe. As I said, it applies to all EU residents. There are specific regulators. So this is another big difference between the EU and the US. The EU has regulators, privacy regulators in each country. And sometimes in particular countries, there's more than one public regulator. In the United States, as I mentioned, the FTC does that, but the FTC does a number of other things. The AG in the state of Georgia would enforce relevant Georgia laws, the data breach notification law, but the AG is obviously not a privacy-only regulator. Individuals have multiple specific privacy rights. They get notice of data processing. Consent is required in many circumstances. They have the right to say, I want to access the data that you hold on me. I want to change it. I want to delete it. So a number of you have heard about the Google right to be forgotten case, where you can raise your hand in Europe and say to Google, I was convicted of drunk driving in 2002, and I'd like you to delete that information. It's no longer relevant. I haven't been convicted of drunk driving since then, et cetera, et cetera. But it's the right to be forgotten. That's a very difficult thing for companies to implement, but you can see from a public policy, from an individual's perspective, that's a very interesting aspect. Now, if you're a public figure, I think it'll be a little bit harder, and there's a lot of details around that, but there is a right to be forgotten. Data portability, if you move from Facebook to Slack, under this law, you could write to Facebook, give them notice, I'd like to port my data to another platform, and they're required to give it to you. There is an aggressive breach notification regime. I think they largely got this from the U.S. with a targeted 72-hour notice, and there are extensive restrictions on transferring personal data outside of the EU. In the United States, largely speaking, and there's a couple exceptions to this, but largely speaking, there's no requirement that companies don't transfer data outside the United States. And there are extensive requirements for businesses, so it's been very, very difficult for companies to implement, even companies here in the U.S. that are operating in Europe. And importantly, there's up to 4% of global turnover at risk for violations. That's a big number. Even if you are a Georgia-only company, but you do business all over the world, under this law, their allegation, or the law would provide 4% of global turnover. That's a big number. So the question is, what does the 4% of global turnover mean exactly? And the answer is no one knows yet. The regulation was effective on May 25th of this year. There's guidance that's supposed to be issued on that very point, but is it 4% of net revenues, profits, 4% of gross revenues? Turnover, I think in a layperson's definition, would mean all the revenue that comes through a company or through a bank account or whatever the case may be. But I think that there's more detail to be filled in there. So importantly, this is all a long wind-up for what happened in California earlier this summer. So in California, if you'll recall, they have a citizens' ballot referendum. If you get enough signatures on a petition and otherwise meet the technical requirements, you can put a referendum on the ballot. And they had gathered all of the technical requirements, met all the technical requirements to put a very aggressive privacy-related referendum on the ballot. They came to the legislature and they said, okay, we're going to do this unless you adopt a law by the date by which we have to withdraw our ballot referendum. So the California legislature, this was in front of the legislature for maybe 2 weeks. And they were really, I think, to use a pejorative term, strong-armed into adopting the law. The GDPR took 4 or 5 years to pass, and in California they did it in a matter of 2 weeks. And one can say that was either the most brilliant privacy-related move in the world because they made something happen very quickly, or one can say that it's, a regrettable exercise of public policy process. So, but be that as it may, this law will be effective January 1, 2020. And you'll see it's quite different than the other laws that we've talked about in the United States, and much, much more like the GDPR. It applies to all California residents in all contexts. Even though the law is named the Consumer Privacy Law, it applies in the employment context, in the healthcare context, et cetera. There is a Hipaa exemption, and there is a bit of a GLB exemption. It allows California residents, and you'll see this is very similar to what we saw under the GDPR, to know the categories of information collected about them, to know whether a business has sold or disclosed their personal information and to whom, to access and delete their information, and to stop businesses from selling their personal information. So if you are a company doing business and subject to the statute, you're going to be required to have an opt-out button on your web page that allows residents to opt out of the sale of their information. That is a very, very large deal, a big, huge change in public policy in the United States. Given that California has the 5th largest economy in the world, it will impact even us here in Georgia and really in all 50 states. There is a very broad definition of personal information that includes household information. So it's not only information related to John Smith or Susan Brown, who lives at 123 Main Street, but it is information related to the household at 123 Main Street. So that goes beyond the individual and gets to a household. And what, a natural question would be, what does that mean? And the answer is nobody really knows yet because it was adopted in a matter of a couple weeks. And it includes the ability to identify individuals via a unique identifier. So if you are on your phone, and they know that you're John Smith or Susan Brown, and then that John or Susan moves to a laptop, they still know it's you via a number of things that are going on the internet, and this law would embrace much of that in various ways. Interestingly, it prohibits discrimination based on an individual's exercise of their rights under the law. So let's unpack that a bit. If an individual presses the opt-out button and says, don't sell my personal data, this law says that you can't discriminate or provide that individual different services than if they had let you use their data. It's a bit more complicated than that, but when you think about it, part of the trade on the internet today is you get free services, free email, free news, free maps, free everything, and what you're really doing is providing data back to the companies, and then they use that data to conduct advertising, which of course finances the information and the website. So under this law, you have to be allowed to participate in those, and there is an exception to this that's probably too technical for this conversation, but I think for those companies that are providing free services on the internet, this is going to be something that they really have to wrestle with and pay a lot of attention to. Importantly, in the breach notification context, this is the first law that provides for statutory damages in connection with breach. So one of the big issues in a breach today, if you participate in a class action, is what were your damages? Well, your credit card companies or the bank or somebody paid for your credit card losses. It wasn't that hard to have the credit card reissued, et cetera, et cetera. So what are the damages? And from a legal perspective, that's important. This law provides for statutory damages in connection with data breaches, and that's a game changer. That will change the way plaintiffs' lawyers think about these. It'll change the way companies think about potential damages in breach, et cetera.
And just as a clarifying point, the term statutory damages, you're saying sort of a per se, you don't have to demonstrate a damage, you don't have to demonstrate a financial harm. If your data has been breached, you have access to a sort of schedule of damages?
That's right.
Yeah.
That's right. If I recall correctly, it's between $100 and $750.
Okay.
And you don't have to prove damages. The court is encouraged to consider several factors. Were they negligent? Was there wanton disregard for security, et cetera, but you don't have to say, well, it cost me $75 in time and energy to change my credit card. So that is a big deal from a legal perspective.
And presumably any actual damages are still recoverable without limitation, correct? In addition to this?
I think that would be the case, yes. Okay. And there will be concepts of no double dipping, so you don't get statutory damages on top of actual damages, but most of these things happen in the class context, in the context of a class action. So damages is a very technical and tricky thing, but you're absolutely right. And so I think companies that previously said, well, damages are difficult to prove, and even insured at particular amounts, they may increase those insurance amounts because this statutory damages issue is going to kind of raise the issue. There's a question.
I may be jumping ahead. Ahead, forgive me if I am, but is this statute being challenged?
So the question is this statute being challenged? It is the subject of great debate.
Any class I mean, I'm thinking about 10,000 users of the Home Depot credit card. That's an immediate class action with an immediate hundreds of millions of dollars of damages.
That could be alleged, yes, ma'am.
If any class action's been filed yet?
No, the law is not effective until January 1, 2020. So it's been passed, and it's been signed by the governor, and it's not effective until
They're
January
doing
1,
guidelines
2020.
in the meantime, and so there really won't be any actions until 2020.
There won't be any actions until 2020 under this law, but I can guarantee you that every lawyer that works in this space
Right.
is paying attention to those statutory damages, and the plaintiff's lawyers will start to point out, as a matter of public policy, the great state of California
It's already said.
X, Y, Z, and we need to take that into consideration in connection with settlement or adjudication of this class action. To your question of is it being challenged, everyone anticipates changes to the law between now and January 1, 2020, because it was adopted so quickly. There are grammatical errors, there are just logical disconnects. It's not the most pristine piece of legislation that we've ever seen, and there are substantive issues that a number of companies are very, very focused on, because if you adopt a law that is obviously that complex, that quickly, you're unable to calibrate it, I think, as closely as you might have otherwise.
I'm trying to think of an example, and you can probably tell me of a similar statute that grants automatic class actions to tens of thousands of people based on statutory damages.
There are statutory damages, and I'll let me rephrase your question so I don't get out over my skis conceptually. There are statutory damages, for example, under the TCPA, the Telecom Communications Protection Act. That's the federal law that deals with robocalls, unwanted texts, et cetera, et cetera. So there are statutory damages in that context, and indeed there are a number of class actions. It's important to note with respect to the California law that there's a process. The AG has the ability to actually take over the case and not let it run through the private courts. So how it actually works in process and whether we see a huge uptick in class actions on that basis remains to be seen. And I don't want to go into the details, but there's a little bit more to it. But I think at the end of the day, there is a legitimate risk that class actions will be prosecuted under this law, and those statutory damages, it sort of doesn't matter whether you're proceeding under that law or another law, you're going to be pointing at those statutory damages as a barometer for damages in the case.
Yes.
And then the last thing that I would say, contrasting this to our friends in Europe, no new regulatory office was established, although the AG will be issuing guidance and is directed under the statute to issue guidance on various aspects of the statute. So the last thing that I would say about this law is there's a lot of talk that possibly a federal law will be adopted. People, I think, are upset and frustrated after things like Cambridge Analytica, data breaches, et cetera, et cetera. So I've been doing this for longer than I care to admit in public, but you know, and there has been talk of federal legislation in this area for a long time. It's not come about. I think it has a better chance now than ever, although it's difficult to say whether it would really occur. You know, there'd be a lot of politics involved in that. So I'm glad to take any questions or turn it over to my co-speaker.
I would encourage members, if you have questions, go ahead and ask some. Plenty of time to do so. Could you push your mic so I can recognize you and get you on the speaker, Mr. Thomas? Could you push your button there so I?
Am I on?
Yes.
Okay.
Chair recognizes Representative Thomas.
All right, thank you so much. Basically, what I want to know is that, okay, I'm on this committee, so I get a chance to hear a lot of different things, but does the average person even know their rights under this? And if they, in that case where you said that if you want to take the DUI off of my record, I mean, if you say that, does that actually happen, or how probable, even though the law exists, how effective is the law for the consumer?
So that's a good question, and there is a lot of thought being given. As I mentioned earlier, in the data breach context, there's this concept of breach fatigue. People don't pay attention to the letters that they get in their mailbox because they've received so many of them. In the United States, a major communicator of what a company does with your data is in the privacy policy. But I think in this room, if there are 30 people in this room, there's probably 29 of them that haven't read privacy policies. And I'd be the exception to that because I write them. So I think the answer to that is most people don't realize their rights. When you go into the doctor's office and you sign that HIPAA consent, you don't really read it. You just sign it. And where your data goes after that, I think the normal person on the street may not really know because these are complex concepts. In Europe, there is a bit of a difference because, as I said, they regard it as a fundamental human right. But I think there is more awareness of these issues after things like Cambridge Analytica, the Target breach, the Equifax, just all these high-profile breaches. It is more top of mind. And Michael, you had a comment.
Yes, ma'am, the question I think is a good one about how much do people know, the average person, but I would also play upon Jim's example of HIPAA. If you were to go into a provider, a healthcare provider, and decline to sign that and read the 29 pages of legalese in 6-point font, what the process would actually be, or that you have issues with any of the privacy notices to which you are presented, yes, you are presented, and you click accept, but the process by which you would execute an exception is, I think, easily characterized as onerous and cumbersome at best, and would cost you a tremendous amount of time and be highly non-standard, right? So I think that there's awareness, but even though those things are being presented as, well, it's not compulsory, you don't have to accept it, except if you don't, you got to go to the basement to a door you can't find and wait in a room that's nobody's there and do 29 jumping jacks on your head with your eyes closed. Like, these sorts of things are just really, really onerous, and obviously I'm being facetious to making a point here, but the ability to say, no, I opt out, sometimes is not straightforward as it might be believed it is.
Yeah, and Michael's right about that, and you see shades of that in the California law with the opt-out button being required on the page. My personal story, representative with respect to that, when HIPAA was issued, my daughter was born March 28th, 2000, and that was in the early days of HIPAA, and we went to the hospital for delivery, and they gave us the HIPAA consent form, and I started marking it up. And this was like at 3:30 in the morning. My wife was in labor, and she stayed in labor, and the hospital didn't quite know what to do. And at 5:30 in the morning, some administrator walks in and says, "Mr. Harvey, we can't admit you." And my wife finally said, "Sign the form." So Michael's absolutely right, and I can attest to the fact that it's hard to. And sometimes as a consumer, it's hard to push back against these things, but you see from a legal perspective, how do you balance those rights? Because the other aspect that you have to think about is this is very expensive for companies to implement. And if you have an exception process associated with each individual, how do you administer that? Who takes care of that? If you have to create an 800 number, which you're required to do under the California law, that costs money. And you got to have somebody answer that phone, and they've got to know what they're doing. And all the processes within the company have to carry that out. So I think there's a double-edged sword here. There's the legitimate balancing of the protection of the consumers, and then there's the need for companies to actually do business and to do business in an efficient manner. I'm going to turn it over to Michael.
We do have more questions, so. Yeah. But if you want to speak to that, you're welcome to.
Well, first, again, I want to thank the chairman and the members of the committee for inviting me here today. It's my pleasure and a privilege to be here, trying to share some of these very delicate, very complex issues and break that down. So I appreciate everyone's time today.
And Mr. Farrell, I'd prefer you not to start your presentation just yet, though.
That's fine.
I do have some questions to
Yeah, please. I was going to do a follow-up redirect if that's
please
okay.
Go ahead, yeah.
So he mentioned processes, right? But again, I do appreciate everybody's time. He mentioned the processes that are in place, and specifically around a GDPR. If you look at the American companies, technology companies that we all know and love every day, people like Microsoft, for example, these are now domiciled in Europe. okay, specifically in Ireland due to favorable tax and some other previously favorable regulatory issues. So with the implementation, with the advent now of GDPR, there is now the requirement to deal not just with the EU, but with the state under which, and again, I'm not a lawyer, I only stayed at a Holiday Inn Express last night, but I'm getting to a technology point. So the notion that you have to interact with the state, the sovereign in which you are domiciled under the EU is one where kind of the GDPR rubber meets the road. So if there is a request made of a company, again, Microsoft is an example, or any others that are in Ireland, they need to go do that interaction, do that follow-up in Ireland. The countries within the EU may or may not currently have the technical processes in place to adequately address all of those requests. They may not have the technical capacity yet to deal with the volume and the complexity of the requests that consumers are making about their privacy and their data. So much in the same way that Jim made a point about the California law potentially being hasty, whether you like it or don't like it, it happened really quick. The notion that even though GDPR was kind of well out in front of people and they could see it, individual member countries may or may not have made preparations adequately to deal with the volume and the pace at which these requests could come into them. And how they execute that technically and the controls they're going to require companies to implement technically are really important because they are not trivial.
Thank you for that, because it gives in that there's impact on the consumer side and obviously on the business side. And I would say, before we recognize there's some other folks that have asked us that do have questions, I would say, the challenge to the issue of you as a consumer at a hospital, we talk about, as we all love and enjoy the benefits and the blessings of the free enterprise system, as we study economics, the classical study of economics is that when we study the free market, there's an infinite number of suppliers, high number of consumers, and as you interact in the marketplace, people can make choices based on an infinite number of choices and infinite variability, and there's often not that. There may be one or two hospitals that you can go to or in rural Georgia, one, if you're lucky. So there's not infinite variability and options that you can say, you know what, honey, we're going to check into a hospital that doesn't make us sign this Hipaa disclosure, or we're going to check into one of the 10 that offers that option. Those options don't exist in reality. So as we have these limitations of options, is it a real consumer choice to opt out of said provisions when, if your wife's delivering your third child, the third come a little faster than the first sometimes, and you just don't have the chance to sort of shop your hospital. So I just sort of say that parenthetically, that you feel this across markets, and I think that's the impetus that starts this conversation. Where we end, I don't know, but I just appreciate that personal example.
Yeah.
Chair recognizes Chairman Martin for a question.
Thank you. I direct this to you and to both of you. Sort of three things, it seems, to address. Let me make a statement and then ask the two questions. It seems like with all of this, we're concerned with our privacy. Different people for different reasons. Some people are, okay, if you want to know all about my health, I don't care if it's good, bad, or otherwise. Other people don't want you to know they got a haircut yesterday, right? And that's an individual decision and one that we want to respect. But we as a society, I think, gain from the collective information that people are doing research at medical institutions, from Johns Hopkins to the medical centers in Georgia, cancer research centers, about everybody's genetic code, and it's getting us places. So the question we have there is a trade-off when you're looking at medical information and so forth. I think we'd have to see about that. But my question goes to this disclosure and the European thing. Has anybody besides me noticed that when you dial your bank or your financial broker now, there's a statement that didn't used to be there? It says, by continuing on this call, you agree to all of our privacy standards. Is that something that I'm just hearing with some folks that I'm dealing with, or is that the global catch-all that some American companies are doing in the event they're getting an international call from somebody in Europe? to go with the European requirement for the full disclosure. When they don't do that, they just say, by continuing, you agree to all of our privacy policies.
I am officially not responding in connection with any particular company. We represent a number of companies, some of whom may have adopted that model or not. But I do think that your intuition is right, that it is an attempt to say, I agree.
Safe harbor.
To say, and what they're getting them to agree to is the harder question. Is it a privacy policy? How does the individual access that privacy policy, et cetera, et cetera. But I do think it is an attempt to address the GDPR and other laws. And in particular, we referenced the TCPA earlier, the Telecom Communications Protection Act, which is the federal act that governs robocalls and texts, et cetera. There probably is a TCPA aspect to it also.
Okay, the next question I have, and this is, we may not be there today, may not be what we're talking about, but I had a conversation with a colleague in D.C. Back in May. We were up there and we were talking about Google phones. And she was actually working on a number of things with Microsoft, Google. It was right after the Cambridge Analytical. And she was working on a research project whereby a professor had several phones. They turned them off and took them, the various research assistants took them with them over the weekend. When they got back in on the Monday morning, they plugged this device into the phone. Without even turning the power on the phone, this device could download what was in the phone. I mean, it's a software product. This particular phone that was using a Google, the Android operating system, knew where the gentleman that was running the survey, they knew, in fact, that he had been to a doctor that morning before he came into the office, and in fact knew the altitude, it knew that he was several floors up in a building in Arlington. And so not only did they know the location, but they knew how far he was up in the building, all while the phone was turned off in this Google system. At the same time, in that meeting I was at, the American Enterprise Institute, listening to a performance, someone introduced themselves and said that they worked for a foundation for the family or the gentleman that invented Hot Pockets, if you've heard the snack food, I suppose. And so Hot Pockets was said 3 or 4 times, while she was doing the introduction. That afternoon, before we adjourned the meeting, so in 3 to 4 hours, several of the people in the room were getting advertisements on their Facebook from Hot Pockets. They said they had never had one in their house, never had one. So the phones, I mean, the only thing that can, the conspiracy, the only thing that makes sense there is the phones heard Hot Pockets 3 or 4 times in a short period of time. I think that's what concerns me more about the privacy issues and what's being collected when we don't know it than, and that's me personally. So let me ask you that question. Is that something we're going to cover today about the collection of data unbeknownst to the people that I represent and my colleagues do in this room, as well as the data we offer them for free email? I mean, it seems to me there's 2 classes of privacy there. Both are concerning. The latter one that I just mentioned is far more concerning to me. About if you think your phone's turned off, most people think it's not listening to you.
Alexa's always listening.
Well, yeah, and you understand that Alexis does, because she has to know, she has to be listening for you to say Alexis. But when you turn this device off, when you power it down, I think 9 out of 10 people are going to think that it's a rock. It's not listening. And it clearly seems to be in the room I was in Washington earlier this year.
So both excellent questions. I would say that the technical details of how that work would take me to put my professor hat on and a long lecture, so I will try to give some brief summaries. But first, I think your fundamental point is well taken, is that it comes back to, again, consumers believe they are buying a product to achieve a particular purpose. But all the tiny little, again, and I'll use 6-point font in letters that are really hard to read, says that we are going to use this product and all the information and data that's going on in the ambient background for the purposes that we seek, right? And the ability to turn that off is either non-existent or excruciatingly difficult, right? As again, an Alexa or any other voice type assistant, right? Apple has one, Google has one, etc. So the ability to execute on your desire, again, a Hipaa, I don't want to do this, there's things I want to change. How do you actually go about and do that? I think that's where we need to drive and focus on. When you ask about the phone, as it turns out, you can actually turn a device off, but later on, it will be able to download other elements of activity that you have executed that weren't on your phone, but through the broader internet and the services that you utilize, right? So, for example, when you use the internet, a Wi-Fi access point. So today, for example, if my laptop right now connects to the state house's Wi-Fi, that is geolocated. Like it is absolutely knowable and known that name of that network, GGA guest or whatever it is, right, is located here at 206 Washington Street. It is probably also well known, and I could probably find it in a few clicks of a search, that it's on the, 4th floor, right? Or 3rd floor, or whatever that network of guests is only available on certain floors. It is probably very well known of that, right? So the ability for folks, whether they be data brokers or that service provider, Google for your Gmail, for example, right, to know that you have done those sorts of things does not come merely from the device that it's in your pocket, but from the many other things that you may or may not have done, right? And that's a very broad kind of sweeping answer, and there's a lot of specifics underneath there. But suffice to say that every time that you make an interaction with a service, whether it be providing access to a network, email, social media, Facebook, scanning a coupon, doing your CVS or your Kroger or whatever card like that, right? All those things are logged. And it's associated with you as a persona, maybe not all the way down to you as a person, but certainly at the very minimum a persona and a time and a location. And the digital dust that we leave as we move throughout our life every day, I think is very much not well understood by the average American and or citizen of anywhere in the world. There's a tremendous amount of activity by just having devices around us, internet in our homes, devices in our pockets for telephony, iPads, these sorts of things. The amount of connections they're making and the logs that are stored about those connections, even if you're not sending an email, even if you're not making a call, right? There is so much data that's out there that's very, very rich. And that this notion of data brokers and how they buy and sell and trade and, bless you, and collect kind of dossiers that are turned into certain products and services, right? I do not think it's well understood. And the amount of technologies that are used to create such dossiers are numerous and growing by the day.
Just quick follow-up, if I can, Mr. And we won't get into the dissecting the internals of a phone, but they went further. Again, this particular example I'm given, they never turned the phone back on for it to connect to an internet to download that information. And I have actually checked this. If you take this phone and you charge it up and you turn it off and you leave it somewhere for 30 days, when you come back, the battery will be discharged. Now, that's either a flaw in lithium-ion technology or there's something inside there drawing some minimal amount of power, obviously to keep the ROM running and the memory chip, afloat. But the question is that centric? I mean, you can tell if this phone is being turned around and gyrated. So that's what I wonder is when that phone is off, is it in fact still geolocating you? And that, you may never see it, but somebody can get at that phone and see that. That's the trouble that.
You make the point well. Off is not off in
Right.
what a colloquial sense is, right? There are the underlying electronics are drawing power to do some base functions, and it depends on model and manufacturer and the chipset and the firmware version and all that kind of stuff. But fundamentally, off is not off, right? And things like the accelerometers and certain things.
Sure.
And some of those things may have been enabled by you, and depending on the software, for example,
Sure.
Android versus iOS, enabled by you to say, even when I turn it off, I'm
check.
actually willfully knowing that it's still on, right? And you might not really even understand that because it's in the buried in the menus of all the different things within the operating system, but off is oftentimes not really off.
Well, and Dr. Harvey, I guess you'll know this. It's early stages, but I know just this week, somebody's after Google trying to get class action status for them tracking people. I don't know if that's based on the California law or just in general the invasion of privacy of them tracking people when the phone is off or the tracking mechanism off. If you could comment that, choose to comment on that legally or just in general.
Several layers of comments. I don't know the case that you're referring to in particular, but Google and the other large technology providers are subject of class actions related to privacy every day, irrespective of statutory damages or anything else. The other, just from a legal perspective, the FCC also does have some regulations pointed at location-based tracking and location information when you're using your phone. But as to the phone tracking you when it's turned off, et cetera, I don't know. The things that I would point out, though, if you notice in my comments when in the California law, first of all, the California law specifically includes IP addresses that Michael mentioned as personal information. So when that data, when Michael logs on and to the Wi-Fi here, well, if he were in California, the IP address would be associated with Michael, and that would be personal information that's subject to the law. And then the other thing that I've referenced in the comments regarding California law is the device identifier. So your phone has a MAC address.
Right.
And that device identifier or an advertising identifier that's attached to your device will be covered by that law. One other thing, though, that I would offer for consideration, since you guys are the ones that make the law, is as perhaps attractive as it would be to adopt a law like the one in California or a version of that or whatever. I think we have to, again, it's a darned if you do, darned if you don't situation. We certainly want to provide the appropriate protection for the citizens of Georgia. But on the other hand, if we have 50 different laws like the one in California, all of which vary in flavor and tone and momentum and details, et cetera, that is very, very difficult for companies to deal with. So it's hard enough dealing with the, as I mentioned, the 53 different breach notification laws. And if you get 50 or even 5 different data use laws, that's how do you do that? If the laws applicable to your phone are different in California than they are in Georgia, than they are in Texas and Illinois, it is going to impact the consumer's experience, and it's also going to impact the cost to serve of the companies that are providing those services. So it's not particularly a fatal issue, but I would urge for consideration that a multiplicity of state laws has a cumulative effect on the provision of services for companies in the United States.
Thank you.
Chair recognizes Mike Sevens, Representative Rakestraw.
Thank you, Mr. Chair. So I want to go back to the privacy stuff with the Hipaa and see if you guys have solutions, because one of the areas that I have noticed that this is really impactful and we put people at risk is in like the mental health system. And so if you've got someone that's maybe bipolar or oppositional, defiant, explosive, and they're escalated and it they have random episodes of escalation, and you try to get them help in the mental health system, if they're over 18, they'll say things like, oh, well, we can't make an appointment, that person's an adult. Ironically, they want to talk to you as the person to pay the bill, but when it comes time to make an appointment, this person's an adult. And so if you've got someone that's in a non-escalated situation and they're asking for help, you need to be able to clear those hurdles. I mean, it's hard enough to get them involved in the mental health system as it is, and typically that doesn't happen on a bureaucrat schedule from Monday through Friday, 8 to 5. So if you have an escalated incident, then, if you call like the police to calm them down or to try to to help them or deal with them, a lot of times they end up in jail where they don't belong, or they go to the hospital for 2 or 3 days and then they get turned back into the environment. And so it's already broken and complicated, but the privacy stuff even complicates it further, because if you've got someone that has, say they're bipolar, or they have mood swings, it's hard to get them to a place. They're really not functioning at an adult level, yet legally they're considered an adult. And depending on what mood you get them in, it's hard to get them on the phone to authorize an appointment. And so things like, even if they're in the system and they've got that disclosure, it's like, oh, well, that expired, that's only good for a year, so now we can't set up an appointment until and it's just really tricky and cumbersome. So how would you, and it puts people at risk, because if they're suicidal, if they're homicidal, they're threatening, you need to be able to get them help while they're not escalated, so that they don't have those incidents, because the way things work, I mean, that triggers the next shooter, and all the problems that we're dealing with mass shootings and people not being able to get the help that they need. So, it may protect their data and privacy, but it puts a lot of people at risk on the other side of that equation. So what kind of solutions do you guys recommend so that we're not having to deal with people not being able to get help because they're not in a lucid moment where they're willing and Monday through Friday from 8 to 5 where they can actually set an appointment and get the help that they need in those non-escalated moments?
There are many, many layers to that question, and I quite frankly don't know the answer. There are, from a legal perspective, obviously issues associated with whether someone is of mental competence to enter into an agreement and sign the Hipaa form or whatever form it is that they're being asked to sign. And our healthcare professionals deal with that every day, and I don't have a silver bullet there. The thing that I would point out, though, is the backside of that equation. What about the mere fact that someone has been admitted for symptoms associated with bipolar disease or sexually transmitted diseases or whatever other sort of sensitive medical data might be associated with a visit? And there are a number of state laws in particular that address the use of mental health care, sexually transmitted diseases, substance abuse, et cetera. And those are spotty, not in every state, but they do exist. So there's both the front end of how do we get them into the system in a rational, timely fashion, and the back end with what happens to that data after it gets into the system, and is that used to the detriment of the individual?
Well, also as a follow-up, there needs to be, a continuum of care where those people can share, because if they do get into the system and once they're there, they get passed off from one person to another, and they need to be able to share that information so that they can best help that patient. And there really needs to be a consistent continuum of care where one person is following, because it's hard to get them to at times open up and build trust with that person, and then once they do, they get passed off to someone else. And it's kind of like the same problems we have like in our DFACS and our foster care system. You've got people that need to share information and follow and track consistently what's going on with, say, a child in the foster care system or in the DFACS system, and it's so siloed and they're not able to share that because of privacy issues, but they need to be able to do that. So, we really need to carve out, being able to help those people with services and a consistency of care, yet not divulge their information to entities that would harm them. So like you were talking about, like STDs or whatever, if they want to say have a career in the military or something and, not share something like that might prohibit it. I see there are instances where you don't want your information shared, but at the same time, we have to be able to share information, especially within, these types of systems, so that information and data doesn't break down that could help, the children in DFACS or in, in the foster care system, or someone in the mental health system, which does put a lot of people at risk if we're not really helping them, but we're just passing them on, and they got to start over, telling their story and their history and what's going on every time they get someone new.
And Representative Rakestraw, I would say too, I think you do raise lots of questions. I'd like to maybe redirect a little bit back towards, or maybe away from HIPAA being in an agency, healthcare, government context, more towards data within the realm of commerce. So I think you have relevant questions. I just don't know that that's the thrust of. I don't want to go too far into that today. If we could, maybe address that at another time. I do have a question. Is it Representative Oliver?
No, my question was asked.
Ask. Thank you.
The one thing that I would say in response to your remarks, though, is all the more to a thoughtful legislative process that thinks these issues all the way through, not only in the healthcare context, but in the financial services context, et cetera, et cetera. The law of unintended consequences in the data arena is stronger and more powerful than ever. So
I agree.
Thank you. I've got a couple questions, but are there any further questions from the committee before we move on? Okay, I do have a couple I've formulated, if you could, for me, Mr. Harvey. You used the term information broker earlier in your presentation, which is a common term you're very familiar with and you use all the time. I'm not clear as to who is an information broker and who's not an information broker, because it seems like a lot of the regulations accrue only to information brokers. Could you define that for us a little bit, sort of who's in that and who's not in that definition?
There is a statutory definition in the Georgia statute, and I don't recall that definition off the top of my head. The distinction that I would make for you is there are a number of largely unregulated information brokers who are not dealing in creditworthiness data. And if you're dealing in creditworthiness data, you are subject to the Fair Credit Reporting Act on a federal level, and your Experian or Equifax or the other credit reporting agencies. There are a number of companies, though, that collect and use data. I mentioned this concept of a household, of John Smith or Susan Brown bought a water hose and they live at 123 Main Street. Someone is likely collecting and harvesting that data, whether they did that online or offline. And then, as Michael mentioned, that data gets sold, and it's known that John or Susan is interested in gardening, and they all of a sudden start seeing advertising associated with gardening or whatever the case may be. So companies collect a lot of data. They share a lot of data with their service providers and with their marketing partners. And I would offer for consideration whether, there are a lot of information brokers out there and they may not even realize that they're doing it. Certainly if you participate in an ad network, so the concept of the Hot Pockets or whatever, if I Google Hot Pockets or golf clubs or tennis balls or anything else, I'm going to see advertisements for that. And there's a network of companies that collect that information and then use it to serve up that advertising. And that's largely on an unregulated basis. They're not governed by the Fair Credit Reporting Act. They're not governed by HIPAA. They're not governed by GLB. So I think the concept of information broker is broader than probably the Georgia statute contemplates. I don't have that statute top of mind, and I apologize for that, Chairman.
Let me ask you sort of a related question that you raised again around those entities that are not regulated and that collect this consumer information. I mean, I think it's not hard to imagine if you were to peruse someone's consumer history deeply over 15 or 20 years, some interesting things can come out of that. And I say this, so I'm going to use some maybe outrageous or some flamboyant examples to ask a question. But if there were a person that was out of town on a business trip, and they swiped their credit card to buy some consumer product. If you had some business person that was from Florida that's now in Las Vegas, and they swipe their credit card to buy goods and services in Las Vegas that are not legal in Florida, I don't know that companies make it a business of putting that out there, but if that can be bought by Target, Walmart, any company to know my consumer history, is that not legally, and it's a legal question, is that not legally completely public data as such? For example, a business person from South Florida goes to Nevada and engages in consumer action for prostitution services, which is completely sex for hire in Nevada is completely legal. Can that now be made completely public legally? Is that not completely publicly available information, or are there limitations to that?
So luckily for purposes of this question, I'm not barred in Nevada. So I'm gonna, but I think there may be laws associated with the use of information regarding legalized prostitution in Nevada. I don't know. Save for those laws, that data may well be available to third parties that are involved in the chain of commerce to deliver that. And on a federal level, on an interstate level, there wouldn't be very much that would prohibit the distribution and use of that information, other than good business practices, because I think it's safe to say that Walmart or Home Depot or Target or whomever the case may be, major brand name retailers aren't going to market to you on the basis that you engaged in noteworthy activity in Nevada. But there may be others that would. So,
and I asked a question about what the legal limits are, because if I buy a garden hose and I go to Home Depot and spend $200 on landscaping, plants and flowers, then certainly the another consumer, Lowe's, is going to want to sell me, their begonias are on sale now, so they'd come buy begonias from us as opposed to from their competitor Home Depot. My question is, if consumer information is passed without limitation basically to businesses and it's bought as an individual specific piece of data, is it not legally open season that someone from Florida went to Nevada and
bought a garden hose.
Bought a taxi ride, or bought sex for hire? It's all legal consumer activity, or purchased contraceptives in Nevada. I mean that's at a drugstore.
So so to the extent that it gets into healthcare data in a drugstore, and I don't know if contraceptives
an over-the-counter consumer item, I don't know that
right.
falls under HIPAA.
Prophylactic.
And I say that not to create controversy on our internet stream, but as a matter of policy. And when you talk about Judge Bork in the 1980s answering for videos that he watched, are we moving towards a world where Representative Wilkerson, who's trying to honorably represent a district in Cobb County, is not facing political opponents that are scouring through, and just like they would do opposition research, are they going to be scouring through his consumer history as a means of attacking him? Is that legal? Is that not legal today? Because I share
so there's a couple things. One, it depends on the type of data and what the representative has been doing at a federal level. We're subject to, and again, I do not think the representative has been doing anything nearly that interesting. But at a federal level, again, it would be the HIPAA or the GLB or Video Privacy Protection Act or whatever. The other thing that would enter into this is a privacy policy of the company gathering the data. So if he's in, a national retailer, they have a privacy policy that will state what they do with the data. The California law would require them to have a policy that states what they do with the data. But the representative who was here earlier and asked the question about, do consumers really know what's going on? Who actually reads those privacy policies? So unless the company has placed limitations on itself with its own privacy policy, or we're in some regulated area, not an over-the-counter drug, but a prescribed drug that would be subject to Hipaa, there's very little that would constrain the sharing and use of that information other than good sense business practices.
And I didn't mean to bring an innocent representative into the question, other than for purpose of illustration. I think, our policy differences across the legislature, I think, pale in comparison to the implications of people's consumer history being able to be paraded out as a, so it sounds like there's very few constraints, is what I'm hearing you say.
Yeah, Mr. Chairman, and Representative, if you have anything you want to redirect.
I just want to ask a question. It doesn't relate to me, visiting the or anything, but thank you. No, suppose we it sounds like currently though there is no expectation of privacy. Then I mean, basically anything that we do can be sold, whether or not we're told ahead of time. That's what it sounds like, because I'm assuming if you're purchasing something with a credit card, I don't get a statement saying this is what we could do to your data. I mean, in certain cases I assume that, but in other cases I don't. And so then we're being asked to wait for the federal government to respond to anything. And I think that's where the danger is that if we wait for the federal government to do anything, it's probably not going to get done. So what may happen is you see other states looking at California and saying, hey, maybe we need to do something like that. So I think that is the risk. You can ask us to be patient, but then once a mother starts getting denied access to something because of something she bought in another state, I think that's the concern that I would have.
Yeah, I mean, can I pause on a direct answer to that and submit for consideration of the chairman? I had some general remarks I'd like to make about data brokers in particular, and I think that might help frame some of these questions and provide some information I think is very relevant and germane to the discussion. So what I'm going to do is I'm going to kind of give you a high-level overview of some risks and potential benefits of data brokers as an industry. But I would first and foremost submit that there is a report that was done by the Federal Trade Commission, right? It was published in 2014. And while that might seem dated, right? So internet years are kind of like dog years. I mean, 1 year in the internet is basically like 2 decades of regular time. So 4 years seems a bit old, but it's actually pretty seminal in the sense that it did a fairly good treatment of data brokers. So again, I would submit to the committee that there was a May 2014 report from the Federal Trade Commission on data brokers that is certainly worth reading. I will try to summarize that for you as best as I can in generic terms in just a few minutes. So fundamentally, data brokers provide a wide range of services and take data from a pretty broad variety of sources. But these are companies, for-profit companies, that never interact with consumers. I will let that resonate for a moment, right? These are companies that are buying and selling and oftentimes literally trading data about individuals, about consumers, and they've never interacted directly with you, right? These customers, an individual has limited access to know what the data brokers have about you, and some, if not all of that data might not even be able to be edited or removed or deleted, right, based on your limited knowledge in the first place. So what I'd like to do is I'd like to, again, just kind of frame what these, and again, these businesses are, they exist all over the country. They, return their value to stakeholders, employ a lot of fine Americans. Again, this is not a value judgment on the data broker industry per se. I just want to try to highlight kind of the pros and the cons on both sides as you encourage to do. So fundamentally, they have raw data that they collect and or purchase, and they also make inferences or use derived data, right? And it is in that not only raw data, but especially the derived and the data they use to make inferences that I think are some of the most questionable things that might want to be looked at the most, right? So you first might ask, well, what's the purpose? Why do we have data brokers in the first place, right? There's a variety of reasons, but I'll tell you kind of 3 fundamentally. The first is to verify identity, right? Make sure an individual that's going to enter into some transaction is actually who they say they are. Number 2 is to do marketing. Right? Make sure that they can provide a targeted consumer with things that are relevant to them. right? So they can better tailor these products and services. And finally, it's to detect fraud, right? To fundamentally say, this is a fraudulent transaction. We don't want to process it. We don't want to pay for it. We don't want you or you to be liable for it. So we want to mitigate that, right? Those are the broad purposes of these data brokers, right? So again, I said that they collect data from numerous sources and largely without consumers' knowledge. That can be things that are online, but also offline. So I've mentioned things like customer loyalty cards, right? So all the major grocery chains, you know, not picking on Kroger, but they happen to have one. I have one on the keychain, right? You go there, you scan it, goes beep, right? And that identifies you as an individual, right? And now they're oftentimes by a QR codes and an app that they have. But they have some way to scan at the register and notify that a persona, which may or may not be tied to you as an individual, because you may or may not have chosen to go online to Kroger.com, again, as an example, to fill in your name, your address, etc., right, your age. But they certainly have you as a persona, right, associated with the identification number on the bottom of that little piece of plastic or your app. And they're logging everything you're buying, and the store you bought it on, and the lane you bought it in, and the time you bought it, right? And all those things, if, again, you were able to read the 6-point font, right, on the back of the piece of paper that you got that little plastic card. I'm not asserting this for Kroger's in particular, but I'm fairly confident in general that there's language that says, we're going to sell that you bought apples, right? And we're going to sell the day of the week and the time, and we're going to sell that, right? Because fundamentally, why are they willing to give you a discount on apples? Because they know you're buying things. They know they can better tailor products or services to you and then make more money later on in those sales or sell those pieces of information that aren't directly relevant to you buying apples, but that are relevant to somebody else that might want to sell you something, right? Second point, this industry is highly complex, okay? There are multiple layers of data brokers, and they're providing data to each other. So they might say, oh, well, I don't really tread in this kind of data, but I'm going to sell the data I have to somebody else. But you do tread in that kind of data. So while in any one narrow particular category, a data broker company might say, I don't talk about age, I don't talk about ethnicity, but I do talk about address, I do talk about income level. I'll sell you age and ethnicity. Would you sell me address and income level? Sure. So all of a sudden now these layers allow for transactions that provide a very broad, very comprehensive picture, right? But even though one individual company can say, oh, I don't tread in that, right? Third, the amount of data we're talking about is in the many, many, many billions of data elements, right? About, almost every consumer in the United States. I could find it hard pressed to find that there is anything more than a non-insignificant fraction of consumers in the United States that these data brokers do not collect data about. And you talk about people that are of a younger generation, and I'll sidestep for a moment whether they're 18 or not, but these are consumers that are now growing up with technology that they don't use cash fundamentally, right, as their primary form of payment. They use credit card, or they use Apple Pay or Google Pay or something that's based, Venmo or PayPal or what have you, right? These are what these consumers are growing up with. So the anonymity that their parents or their grandparents or other caregivers have kind of tried to teach them is almost not, I would say it's not unavailable to them, but it's highly unusual to them. Because the services they use to provide payment for a transaction are, fundamentally trackable to a very, very high degree that cash is not. Even a paper check is not, right? Next, the data brokers not only combine, but they do analysis on, right, this data about consumers to make inferences, right? And this is a point that I think is the most potentially salient for those potentially looking at policy and legislation. What sort of inferences are we talking about? Some things are innocuous, right? Are you a dog owner? Are you a winter enthusiast, right? So these things might be interested so you can get a discount on dog food. These might want to sell you skis or snowboards, right? Or, warm coats. It seems innocuous, right? But there's other inferences that are made that are actually quite sensitive. Again, this has to do with gender. This has to do with ethnicity. This has to do with income level. This has to do with marital status, right? It has to do with health. I'll give you a simple example, right? I have two grandmothers, both deceased, God rest their souls, that both had diabetes, right? When they were still alive, I myself, on my own computer, using my own web browser, would search for and buy monitoring and test equipment for their insulin levels, right? I have kids. They like ice cream like any other kid. I go online and I search for where the ice cream place is, right? In and of itself, those might seem innocuous, right? But it is highly possible that data brokers create categories, and there is an actual category that data brokers do have that they make an inference about called diabetes interest, right? So if they were looking at the information that I use to buy on an online retailer, right, having done a search for it, for glucose monitors, right, insulin tools, and then later that I go ahead and I buy ice cream or look for ice cream stores, right, even though neither of those are for me, I don't have diabetes, I don't take a prick every day, and I don't happen to eat a lot of ice cream, right? I eat a little, but my kids eat way more ice cream than I do. I actually don't have any substantial risk of diabetes more than the average person, right? But that category of diabetes interest would easily be made by an inference of these data brokers to say, well, phew, he tests for insulin, he's going to eat ice cream, he is of diabetes interest. And furthermore, somebody who procures data of a diabetes interest category from a data broker could say, he's a high medical risk person. I need to charge him more money. It's a trivial example, but it is not very far off if it is not happening already, right? So the notion of what these data brokers are collecting, how they're in a layered fashion selling and transacting with each other, and the inferences they're making, right? These can be very dangerous. I'll also say that there's a risk that the inferences are not only unhelpful, but also inaccurate, right? So you may be unable to actually conduct a transaction because the data that was collected by a data broker was wrong, or the inferences they made were wrong, and thus the derived answer that a provider, a service provider, a consumer, somebody selling you a piece of clothing or a product might say, I'm not going to sell to you based on the information the data broker provided me, right? And it's flat out wrong because the raw data was wrong, or their model or their algorithm to generate the inference was wrong, right? There are many, many cases you can look on the internet yourself right now and look on the web and find out that many companies are using machine learning and artificial intelligence to make a determination, should you be able to return a product? Should you be able to even buy a product in the first place after you've made so many returns? Many examples, again, almost replete if you do a good thorough search, on people that have plenty of income, good credit, they have not defaulted anything, they have simply followed the return policy of an organization as stated and followed it to the letter, bought products, they haven't felt good, what have you, they returned them, right? And after some number, they are now not allowed to buy a product on that site anymore. And it's not only because the provider itself, Acme.com as a sales site, has determined based on information they have on their own site, but it's based on other information they've collected from data brokers about your purchase or transaction history, right? So I would say that. And the last thing is that, again, they combine both online and offline data. It's not just things you do online. Data brokers peddle in and transact data that is from offline as well. So a lot to digest, right? But I would submit that there are reports out there, like the FTC has done in this 2014 report, that provide kind of fundamental information on the industry. There have been other states, I believe including California, that have done further follow-ups on these agencies, and it's worth knowing. Now, before I quit, I will say there are obviously many benefits to them to talk about both sides, and that is fundamentally they improve their product offerings. They improve their efficiencies. They sell you things that you want, and they make what they sell you better, right? They absolutely tailor ads, but more importantly, they're allowed to either prevent or reduce the amount of fraud. That allows them to be more profitable. That allows you to potentially not be a victim of fraud. So there are several use cases that are very valid and very valuable to having such an industry. But it is not widely understood. It is very dark and complex, and these people don't have a direct relationship with the consumers whose data they use. So a mouthful, but I'll give that back up to the committee to chew on for a moment.
Thank you, Representative Martin, Chairman Martin.
Essentially, Dr. Hay, you got to that. The question I was going to ask before we went to you was just that the loyalty programs out there are essentially that we think retailers are doing that to give us something, and they are, but they get a value from it, because I've been in places, just run into a CVS and you're grabbing something with a cash thing, but they want to know if you're a member of their loyalty program. So, and they're like, why? It's $2, it's $2 for a couple of packs of gum, but they want to know you were in the store. So that's the question, I guess, because that you brought up. I love the analogy with the diabetics, with your grandmothers, and the ice cream from your kids, because there are a lot of people out there that like the idea that I'm shopping for tennis shoes. I mean, I actually had a business model back in the late 90s that was going to be an opt-in business model rather than eclectic when you aren't looking, but to basically, if you were on an ad and you liked it, you clicked a key and that linked your information directly, and then you would get ads from that retailer. And it was amazing what retailers would pay for a list of people that were interested in tennis. If you wanted a list of all the people that lived in Alpharetta, they would maybe give you a penny per email address. I'm pulling this completely out of pay no attention to the dollars and cents of it, but if you could provide them a list of people who had tennis lessons, it was dollars for those addresses. So those things are very valuable in the world today. My question to you is, there doesn't appear to be now, might there be, or how do we regulate it? And I suppose that's what we're trying to find out with these laws of some of this is good for us. I mean, if I'm looking for right now somebody to do some type of work on my house to do the deck. Yeah. I'd love to go to Decks R Us and somebody to see that, and 3 more deck companies, call me to give me an estimate. So how do you have an analytical thought or way that we can put a governor on that information? Because that is the difficulty. It's like, I want you there when you're helping me, but I don't want you to have that information to somehow it be a disadvantage to me as a consumer or an individual.
So certainly you raise a good point. Again, and I try to make that at the end, but I'll reinforce that. There are valid and valuable reasons why this sort of data is actually beneficial to consumers. So it is not a one-sided street. And again, that is not to be negative against any of those particular companies. I have friends and colleagues that work or have worked in those companies, right? Some of the technology they're doing has absolutely advanced some critical functions of the internet, so no doubt. Drawing that line is something that I think policymakers should consider carefully, but it is imperative that consumers and your constituents understand it first. It's almost impossible for you to get feedback from your constituents if they're not even aware of it. If the average consumer doesn't fully understand and there's not more transparency and at least a little bit of light shed on this, right? Not in a indictment, good or bad, judgment left or right, up or down, but have a better understanding of how this operates so that they can say, oh yeah, I got a discount on my deck or on my dog food because of this. I value this to some degree. Or, oh, I might have had some higher insurance premium because my grandmother was a diabetic and my kids like ice cream. I work out 5 days a week. My health is just fine, right? But I got penalized in some financial way for that. Maybe I don't like that, right? To continue my example. So we need to be able to make our own value judgments, but we can't make those value judgments if we don't understand how this kind of industry works. So again, things like the 2014 report from the FTC about data brokers, things like that I think are worth reading and having constituents kind of read more. I'll kind of redirect one other thing, and again, this is not based on as Jim and his firm has clients. Again, Georgia Tech has sponsors, our research collaborations, right? So we have very strong research collaborations with companies such as Facebook that are working very hard on issues of technology and privacy and security, right? That are going to ultimately, fundamentally, hopefully benefit many internet users. So again, this is not an indictment of Facebook in any way. But I would just have everybody think for a moment, how much infrastructure do they think it takes for Facebook to run Facebook? How many computers? How many data centers? How many engineers? Right? How many buildings? How many electric bills? Right? It is a non-trivial amount. It is a many billions of dollars amount. Right? They do that for free to us because the data that we are putting onto that platform, and that in their terms of service, which are continually changing and evolving and based on GDPR and other things changing, right? Because it's of extreme value to them. Their market cap as of 3 minutes ago was over half of $1 trillion, $503.57 billion as of 11:33 a.m. Eastern Time today, right? That's not for no good reason. That's because there is data that's very rich, okay? And with the advent of the ability to store information rather cheaply at large volumes, with the advent of computing technology that's far advanced based on things like Moore's law and the ability to put more transistors and have more chips that do more processing faster to do computations on it, and with the evolution of models and algorithms that machine learning can now do to give you answers very quickly, find relationships very quickly, there's a lot of value in that data that's intrinsic in ways that we as individual consumers probably don't understand. But the advertisers, the retailers, the other people, they do understand it, and they're willing to pay for that, right? So again, another deceased relative of mine, my late grandfather, told me, God rest his soul, that there is no such thing as a free lunch. And I know that sounds very pithy and trite, but there is no such thing as a free lunch. That app that you have on your phone for Facebook, that website that you use, that takes thousands of engineers who all make very good money sitting in places like Menlo Park, California, right? Data centers, tens of dozens of data centers, right? I mean, that each cost in the tens of millions, hundreds of millions to build. They do not make this investment. They do not make that kind of profit if the stuff that they're trading and selling is not of value, right? And I think it's the debate based on Cambridge Analytica, based on hearings, based on things like this, Mr. Chairman and members of the committee. I think it's a good public service that people understand it, and that your constituents are allowed to come to their own views about whether the value that Facebook provides in tailoring an ad or letting see the cat pictures or baby pictures of their friends and neighbors and all these sorts of things, whether it's worth it to them to give these things up. So again, this is not an indictment of Michael or Georgia Tech or anybody else against Facebook or any other company, but the magnitude of the data and the value in it, I really don't think an average consumer understands. And again, I'd love to have Jim chime in on that.
Jim, if I can just, and I'll step back out of this, Chairman's been very gracious to me, but you made my point exactly. There was this other thing at one time called MySpace, and I think that the actual difference, I mean, they both were collecting information about you and putting it out there. I think the difference between Facebook being $500 billion and is MySpace still available anymore?
It's long since dead.
Was the fact that the CEO, Zuckerberg, some of the other people that run the company monetize the platform, and that's what, I guess that's why I still have to work, because I was one of the guys when Facebook came out that said, well, where's the revenue model? They're giving everything away. And we've discovered now what's under the covers, and the revenue model is the information mining.
You're giving it away.
Right.
So I think all good points. The thing that I would also offer is I think we've now reached an inflection point. There was a question from a representative earlier in the hearing or in the testimony about do consumers even know? 5 years ago, certainly in the United States, 5 years ago, the normal person on the street would have no idea of this conversation, of information brokers, of the fact that they bought a water hose and not notice that the next time they got on the internet they saw advertisements for garden goods. Now the average person on the street, after Cambridge Analytica, some of the other sort of high-profile things that are going on in the data world, things like the example of the phone not being off, people are starting to pay attention to this more, and that's the dynamic that resulted in the California law. And that's the dynamic that really probably, at least in part, drove our gathering this morning. And it's going to continue to drive it. I would say that individuals need to know what's going on with respect to their data and then be allowed to make choice. But the hard part is balancing that against the need to provide goods and services in an efficient manner. And that's a very difficult balance.
Yeah, and I guess one again, to say one more thing. These companies are highly innovative, right? The Googles, the Facebooks, the Apples, the Amazons, these companies are driving innovation for the internet, for the world at large, that it just literally has not been seen before, right? The amount of progress they're making, not just in being able to sell things, but fundamental computing and networking technologies is tremendous. It's fantastic. They are basically hiring some of the best and brightest there are, right? And they really are innovating in a way that I would argue, if not many centuries, has not been seen before, potentially, right? And we certainly wouldn't want, via policy or regulation, to stifle that in a way that's negative for the market and for consumers, right? No one here, certainly me, I'm not here today to suggest that at all. And if you look at the history of what some of the Europeans have done, again, they have a fundamental perspective at their core, right, dating back to historical events, of the 20th century and earlier, that really drive them towards personal privacy. But the amount of innovative and the amount of creative output and technology development that the American companies have done is staggering, and it really dwarfs what the Europeans have done. It really does. So we would not want to embark on a state or a national program to very much restrict, very much regulate, over kind of penalize, right, those companies to stop innovating, to stop developing. We do not want to do that. And I want to, again, be very clear on the video record that I'm not suggesting that. I'm simply saying that an educated debate, a healthy public debate about what is and what isn't, is good for all. And a thoughtful, considerate debate is worth having.
And thank you, Professor. That is exactly why we're here today, as you stated. I'm going to recognize Representative Rakestraw first for a question.
Thank you, Mr. Chair. So, a couple things. So, this seems like we've kind of set our model based on, I remember back in the days when the Direct Marketing Association set up the opt-in, opt-out. They wanted to self-regulate rather than have government come in and regulate them. And it was, based on email addresses, and, you couldn't email someone unless you opt in, and you had to have that whole, and so it seems like all the law that's been created has had that at the center, but the market has really evolved in that, we're not only dealing with sharing of information, but we're dealing with, okay, for instance, when you opt into like an Amazon Dot or Echo or whatever, or even the cell phone agreement, beyond just keeping your phone on for 30 days, people can have conversations and not even Google something, and then they start getting advertisements for something they just talked about. Just where it was listening, and to me that's a huge invasion of privacy. But the other thing is, earlier this year we had someone that I think they presented to this committee.
Could you pause for 1 second? Just
Yeah.
to your point, is that true? Can a conversation on a phone
Near a phone.
or near a phone
Near a
lead to
phone.
a data event that drives that?
Yes,
Is that
it's happening.
So
Yes.
what I imagine, again, I do not have the context of the case, and I'm not going to speculate specifically, but my guess is that there was an app or a service that was on your phone that you had authorized to have access to the microphone, and it might have put up a pop-up menu item to say, hey, I want access to the microphone, okay, yes or no.
With
Or it
a
might have been
30-page agreement that you don't read.
The default of, for example, and I'm not saying this is the case because I don't use the Facebook app, but if the Facebook app, as an example, I'm not saying this is what they did, but one of the apps on your phone, you have given permission for it to access, quote unquote, the microphone, or access, quote unquote, the camera, right?
And it's all predicated on that opt-in, opt-out policy that was
And so
created
it
years
was
ago
listening
with
all
the DMA.
time, right? And it basically heard the word Hot Pocket, and you didn't Google it, type it, anything like that, and all of a sudden you get Hot Pockets, right? I'm getting hungry, by the way, Representative. I'm kind of feeling like some.
So-
Who wants ice cream and Hot Pockets? Raise your hand.
Well, the other thing is, I wanted to I think it was earlier this year, somebody presented to this committee, and they talked about how, with their whole predictive modeling and their algorithms, they can actually determine when a woman gets pregnant 2 weeks before she even knows about it. They have figured out how to analyze.
There's a well-known story. Again, if you search for this, it's based on a father who got an ad. I believe it was from either one of the pharmacies or Target about. He was receiving things in his inbox for his daughter who was under 18, and it was addressed to her, and it was about maternity clothes and about all these sorts of things. And he's like, "Why are you sending me this stuff?" And he was very passionate about marriage, and he had certain personal beliefs. And he's like, "This violates my personal beliefs. You're sending these things to my home. Why send it to my home?" And it turns out that the store was right. His daughter was pregnant, and she either knew and hadn't told him, or didn't know herself. But based on the things that she had been searching for, the products that she had bought, right, they determined, right, that she bought all these tests, and then she stopped buying the pregnancy test, right? And again, I may have the details inaccurate, so please look at the story. But she basically stopped buying the test, and then she started buying maternity clothes. So all of a sudden they start sending coupons, and this father, I guess rightfully so, lost his mind, right? And basically they're like, "Actually, sir, you better go talk to your daughter because our algorithms tell us that we're probably right."
So
And
okay,
they were right.
so but when they testified, they said actually before the mother knows. So at that point, she would have had an idea, maybe. I don't. Anyway, so you're saying that's how that came about, that she bought a pregnancy test or something somewhere?
So we've gone into way sensitive territory here, but I think that one of the other data components that they're looking for is purchases of feminine products. And when those purchases get delayed, that indicates that the person buying those products may in fact be pregnant.
Okay.
So
It's still
different,
scary,
a little
just
bit different,
saying.
different than Michael's story.
Many
but-
data points, many ways to go about it.
different than Michael's story, but the flip side of that is when you log on to your online banking and they say, oh, we don't recognize this computer, please answer these security related questions. Have you ever lived at this address? Of these 4 cars, which one did you buy? And you're reading these things and you're thinking, how the heck do they know that? This is just my bank.
Mm-hmm.
But on the other hand, there's a real value to our society for them to be able to present us with those questions because that prevents fraud. So it is I think Michael's point, one of the points that Michael made that I agree with strongly is it's a massively complicated ecosystem.
Mm-hmm.
And knowing everything that goes on and what legislation would be appropriate is very difficult.
So the question is we're really,
Okay, so
so
let's,
the question is based on, I mean, it seems like we've kind of built and evolved and this has morphed around the original opt-in, opt-out for the emails that the Direct Marketing Association was involved in back in, I think it was like the 80s or maybe 90s. Maybe it was the early 90s. And so we've sort of just added on and evolved that model from there so that, you know, all these companies do is have you fill out a 30-page agreement that you're not going to read and say, oh, yeah, okay, I'm good with it. So do you think that if we sort of unraveled that and took a different approach that wasn't based on the whole opt-in, opt-out system, that it would be more protective? Because it seems like at the core, if we're kind of driving off of that and that, you know, protects them yet doesn't really protect the consumer.
My personal view, not the view of my firm or my clients or potential clients, my personal view is that there will always be that once individuals have notice of what's actually going on, then you have to give them a choice. And whether you do that on an opt-in basis, which has all sorts of ramifications, or an opt-out basis, which has all sorts of ramifications, those are policy decisions. But that element of personal choice, and you're right, the DMA did put out a number of industry standards to help them avoid legislation and regulation on this process. But the concept of the consumer knowing what's going on and then making a choice with respect to what happens to their data, I think that's the tide that we're feeling with the GDPR and with the California legislation. And inevitably that's the tide because people are now going to have an expectation, whether you live in Georgia or Texas or Ohio or wherever the case may be. The fact that you can call up in California and say, stop collecting my data and stop selling it to a third party, people are going to start expecting that everywhere. So I think opt-in and opt-out is with us for a while, probably with some legitimate reason.
Does that work better than the do not call list? Because it's not working. I get calls all the time on my cell phone.
yes,
Yeah.
indeed. I appreciate that, Representative Rakestraw. Next question is Representative Wilkerson. Sure.
I just wanted to add something to that.
Representative Thomas, could you push your mic for me so I know which one you're?
Yeah, I did.
Are you 4? Okay, you were next.
Okay, cool. So I just I had wanted to say that when Chairman Martin had posed his question earlier, but you know my comment to that is that you know every time I open up an app or if I buy an app on the Play Store, it definitely says like are we allowed to make and manage calls? And that's I've always you know asked like why do you want to manage my calls when this is Candy Crush? You know what does that have to do with anything? So I was just trying. I don't think that we can legislate that, but I've always wondered, like, why do they want to make and manage calls? Like, what does that mean? Does that mean give our numbers to telemarketers? You know, like, do you know what that means when it says make and manage calls?
I don't know what that means. When you mention calls, it makes me think of the TCPA,
Mhm.
which is the robocalls and texts. But I've not seen that make and manage calls. I don't know. Michael, you may have a thought there.
There's a principle around security that says you give the least amount of privilege, the least amount of access, essentially the least amount of functionality required to do the job, right? So if you're there to play a game, right, Candy Crush, for example, it shouldn't need your microphone. It shouldn't need your camera. It shouldn't need to go send any data back. It shouldn't need that, right? So if you are ever presented with those options, Michael's personal, again, not representative of anything else, but my personal opinion would be, don't give it access, right? Understand what purpose you are downloading that app or using this service, and say, I'm going to give you the bare minimum amount needed to do what I ask you to do, which is, show blinky lights and take my thumb's directions. That's it, right? So fundamentally, I would encourage, again, everybody, as part of the general thoughtful consideration of this, is that we understand what the best practices are, and whether it's opt-in, opt-out, whatever, you are being presented oftentimes by your device or by the service, hey, which of these things you need, okay? LinkedIn's a great example. How many people here have LinkedIn? I bet a lot of people have LinkedIn, right? Have you gone in, or Facebook, or any of these accounts, right? Have you gone in and looked through every single detailed setting of privacy and what they can share and what they cannot, right? Now, LinkedIn, for example, I happened to browse this one recently, but they kind of say, hey, I'm going to sell this. I'm going to sell it to recruiters. I'm going to sell it to this. I'm going to, this or that, right? But it's all turned on by default, right? And it's not hard, but it's cumbersome to go in and uncheck each one of those, right? As a general rule, it makes sense to understand what purpose you are utilizing that service for and what benefit you might derive. Maybe you are trying to find a new job and you want all this stuff to come to you. So maybe you want to leave those turns on. But make an informed decision about what's there, what controls you have, what elements of information that you're basically inherently giving them access to, if those things are available to you. If the granularity of control is offered to you, take advantage of it, right? So again, I would submit to the chairman that as a part of your committee's hearings and dealings, and again, even considering potential legislation, please go back, all of you as representatives, and encourage dialogue with your constituents about these issues. Have them understand that it makes general direct impact to them and their families when you give this data up, or what the value is. Not imposing a value judgment, but encouraging them to make their own value judgment about the pros and cons of it.
Yeah, I think I that's something that I do every single time. I won't even play Candy Crush if they're gonna make it manage calls. But the next question is, I know it was easy for you to look up the market value and everything for Facebook. I wonder is there a way for us to look up how much money that, for example, I'm a Samsung user, how much money Samsung is making off of our data? Because that's something I've always wondered, because I know I have actually tried to look, just like Representative Rackshaw said, I tried to look and see, all of the terms and agreements. I mean, you'll be looking for days on that, how much they have access to. But I would like to know, is that publicly available to see, how much money they're actually making off of our data?
So there's no law that requires them to publicize that information to the public. If they're a public reporting company and publicly traded, they have certain obligations to make their revenues, profits, et cetera, known. And whether they disclose the different parts of their business, that's a very complex question. But as a default matter, the answer to that is no. You may be able to drive down into a telecom carrier's or device provider's financial data and figure that out. But as a default matter, I think the answer to that is generally no.
But would you say that they make probably a lot more money than what we pay for the phone?
I think they make a lot more money than what we pay for the phone. Whether they're doing that on the basis of data or some other basis, I don't know.
I mean, I say that to say I don't know if this will happen in 2027, but we pay $800 for a phone, but they're making so much money off of our data. It's like they should be giving us phones instead of us paying $800 for a phone, and you're making maybe at least $5,000 just off one person for a year with advertisement.
Yeah, I can't speak to the exact breakout of revenue, from any particular device, right? So Apple's is probably the most direct, but I can't speak to the others. What I would say, though, is that, again, as a general rule, understanding those business models is not always straightforward from what you look at the balance sheets, right? There's a famous, literally kind of a case study, business management 101 example in universities that has taught about things like the printer business, right? So this notion of inkjet printers, They sell inkjet printers essentially at cost, sometimes even at a loss, because your printer isn't worth anything if you don't have ink in it to print. So they make a lot of money off of that ink. So again, we have as consumers, we have a pretty good grasp on things like that, right? If you go to a certain restaurants, you realize they're not making a lot of money on that chicken breast or that salad. They're making a lot of money on that glass of wine they sell you, for example, right? We have understandings, visceral understandings of the kind of business models, right? In this instance, I think the average consumer, as it's increasing in the last couple of years, but these consumers don't understand the business models of the Googles and the Facebooks and providers of certain data consumer electronic devices, right? We don't have that good kind of understanding of the business model, and thus again, it's hard to come back as a consumer to make a value judgment personally about whether that's worth it or not. I just want to foot stomp that for like the 5th time. I'm not saying that one is right or wrong. I would encourage the committee and constituents to understand, make decision and value judgment for themselves, but based on all the light of day and facts that there are to understand. Right, and I think that it's just not very transparent.
Thank you.
Is that all you have, Representative Thomas? Yep. Thank you. Members of the committee, we have about 30 more minutes to go, so we do have time for a few more questions. And if you all have, because we are going to wrap hard at 12:30, if that's okay.
Yeah, actually, if there was a way to potentially get that done earlier, I actually have a flight from Hartsfield at 1:35.
Yes, sir.
So.
We will wrap it. We'll wrap sooner.
I do have pre-check, and I'm not checking the bag, but
And I also had booked this at 12.
Good. Okay. Then we're going to wrap here. Could we go to 12:10? Is that possible?
Sure.
Okay. We'll wrap at 12:10. Chair does have some questions. I've kind of been holding on. One of it was one of the questions I think was alluded to indirectly. You talk about consumers who see this opt-out potential being a legal duty for businesses in California. What implications does that have outside of California? I think about environmental regulation. When you've got multinational companies that have EU's governed by one environmental policy, the United States is governed by another one. Perhaps a South American country where they have industrial holdings is governed by another. On the tort side, they've over decades, there's sort of emerged this duty that if you're protecting certain employees from an environmental health and safety standard in the EU to this standard, and the United States in this standard, asbestos, for example, you can't just subject people in South America where there's no asbestos regulation to asbestos exposure just because you don't have to by law. There's this sort of this theory that's emerged around common levels of support from a tort standpoint. Do you see any potential from a tort perspective or from a civil perspective that when a standard of care emerges in California, that could be enforceable outside of California potentially?
So, I don't know if I would put it in terms of the standard of care, but recall the example that I used where I said even though a company may not have a technical legal obligation to notify in Georgia because of the narrowness of the law, they may notify anyway because they think that's a good business practice. So I think from a practical perspective, as consumers' expectations change, they will say, well, I was dealing with so-and-so that was selling me tennis supplies, and they were a California company, and they had this opt-out thing. And I don't want to deal with some other online company that doesn't have an opt-out thing. So I think there is the market will push some of that. I also think from a legal perspective that there will be, you use the term standard of care, in the security world, as Michael knows very well, there is an emerging sensibility. NIST, the National Institute of Standards and Technology, has released a bunch of guidance on cybersecurity. So there is an emerging minimum standard that companies are increasingly being held to. And certainly the plaintiff's lawyers, if you're in Ohio or Illinois or Indiana or wherever the case may be, even if that's not a part of that state's law, they'll say, well, wait a minute, there's a federal standard on cybersecurity that said you should have had these 3 controls in place, and you didn't have it. Okay. So I think the market will push you there, and I think that the legal system will push you there to some extent, because data is very much like the environment. It's difficult to legislate on a jurisdiction by jurisdiction basis. And it's also companies that are now complying with the GDPR. When they look at the California thing, they're going to have to comply with the California thing. So very much the combination of those two regimes is going to set the standard. Maybe not in exactly the same place, but to the extent that they overlap, you're going to have to go to the lowest common denominator.
You did mention the idea of cybersecurity and data breaches. Let me ask a quick question, or what I hope is going to be a quick question. With respect to data loss, in Georgia, from the perspective of sovereign immunity, or what governments are exempt from civil exposure with respect to sovereign immunity if they were to release data? Is the state, if they were to release the kind of data you're talking about, subject to civil action, and our local governments subject to it? School boards and cities and counties?
I do not know.
Don't know. Okay.
The Georgia Tort Claims Act gives you some indication, but that's a pretty complicated question right now.
Yeah,
You know,
that's
Georgia's sovereign immunity mess that we're in.
Yeah, I do not know.
One last question for you, and then I'll let I have, I think, one more from the committee. How would we interact with our data if we wanted to? I think it's what I heard Representative Thomas alluding to. If I wanted to pursue the data that's being transmitted on me, I wanted to sort of get to it and find this mother lode of data out there. How would one even start the process to do that, or is it really an unsolvable problem for a consumer?
Certain providers do give you an ability to look to see kind of what they have. So Google is one. There are steps that you can take to basically go download a giant hairball of what they have about you, and it's sometimes not always that well organized. So the Facebooks and the Googles, I know, both are starting to offer that. Again, it's not always easily parsable and readable and all that, but they are saying, hey, here's what we have. There have been questions in the community about how the completeness of that kind of package of data or the timeliness of it, but they have taken steps which are, for them, in considering the past and their business models, quite significant steps and technically meaningful steps to kind of offer you that. And again, I can try to dig that up and send it to the committee later to have those kind of steps, but it's on the Google website to how to download that. Not all service providers have done that, and not all service providers have essentially been asked to do that. So again, one thing that might be helpful is a broader encouragement, right? So maybe a carrot rather than a stick, potentially, of encouraging these providers to say, hey, look, you're the top 20 common providers of sales or social media services or communication products, what have you. It'd be awfully nice to make sure you have some mechanism by which an average consumer, average user can go and download to see what it is you know about him or her, right? So there are some companies that are starting to do that. Not all have, but there are a few that you can do that with.
The other thing that I would say is in each sort of data intensive part of your life, there are increasingly options. So if you look at your phone, you have the ability to turn on or off microphones, camera sharing, location sharing, a number of options within most of the operating systems for the phones. I've seen recently with Note several articles in national newspapers, et cetera, about how do I control my privacy settings at Facebook, Google, Twitter, Instagram, et cetera. So there are opportunities for individuals. They're very complex, and I think that's something that the industry is focused on, is how do we make that simpler. It's a difficult issue, as you can see.
My last question. Is there legal exposure to sharing data outside of a country, outside of a legal environment where action can be brought for misuse of it? For example, in the European model, there's a prohibition of sharing data outside of the EU, sort of outside of the realm of the civilized world with respect to where data is. If someone collected my data and they sold it to somebody in the United States where if it was misused, I could bring an action against them. But if it were sold to somebody in Lithuania or Mozambique, where there was no ability to recover in a court system that we would maybe recognize and would respect rights in the same way, is there an ability to get an action against the entity that shared the data outside of my legal reach?
If they're in the United States and they were violating a law, by having shared that data. So, for example, they violated Hipaa and they sold it to someone anywhere in the world, Lithuania or Mozambique. Yes.
HIP is easy, but
HIP is easy.
but with respect to consumer data or other financial data, let's say there was no legal prohibition to share it outside of the United States, but it was shared with some entity in the sort of stream of global commerce that then used that against me. I can't bring action against them, Interpol. I can't get Interpol to do anything about that. Is there an action because of a chain of responsibility? Can an action be brought against an American company? Or could they say, hey, we didn't violate any law, we didn't violate any duty, I'm sorry this bad thing happened to you from this source to which I sold it, but is there any way, I guess what I'm asking is this concept of rendering data outside of an environment where there's legal accountability, is that really the issue that the Europeans were looking to address? Is that something that's relevant in practice?
So that's as the representative referred to earlier, a very complex question. What I would say is the Europeans have very tightly regulated the transport of data, personal data, outside of Europe. You can do it, but it has to be done under very specific circumstances. That's largely not the case in the United States. If this were a multiple choice test and I had to take it today, and I had to answer that question, my answer would be probably not. Yeah. Unless they're violating a law, unless it's, let's call it regulated data, HIPAA covered data, GLB covered data, or unless the company has a privacy policy that says we will not do this, and they in fact do it, you may have a cause of action there. But aside from that, there's very little that could be done.
Okay. Last question goes to Vice Chairman Rakestraw for a quick question.
Question too. So who's? Okay. So 2 real quick questions. So would it make sense that that if we went to, you're talking about Google has pieces of information, but there's so many pieces out there.
Rakestraw, we are going to have to, one quick question.
Okay.
I need you to.
Well, there's 2, but okay. Okay, so one of the things, let me ask this other one then. Yeah.
I'll answer as best I can. Go ahead.
Okay, so would it make sense to add a dimension versus the opt-in, opt-out to say, I need this software, it does something for me? Because if you opt out, you know, a lot of times you don't have access to it and you don't want to expect them to give it to you for free. So if you added a dimension to it to say, I'm willing to pay for this with you to not collect data on me, but I'll pay to use your software so that it still has the features and benefits I need without giving away my information.
So that's when I talked about the non-discrimination aspects of the California law, that's exactly what that's going at. And there is the ability in the California law to provide financial incentives for data sharing. So I think you're starting to see some of those concepts emerge, which may take us beyond, as you say, the opt-in, opt-out regime.
Mr. Yes, if people are willing to say, hey, Facebook, don't sell my stuff, but I'll give you $50 a year, $100 a year. Right. You can make money off that way.
That's what
that dialogue is going to be interesting. It's going to be a price point thing, or we're going to figure it out by market forces, right?
Mr. Farrell, thank you for being with us today. You're a huge addition to our committee here today.
Thank you for the committee's opportunity. I would be remiss if I didn't say at Georgia Tech we are actually doing a ton of research and education on both security and privacy. 2 of my colleagues, Professor Peter Swire in the Scheller College of Business and Professor Annie Anton in the School of Interactive Computing, are both taking different approaches. Professor Rachel Cumming in the School of Industrial and System Engineering. There are several faculty members that are working on both technical and policy elements to how these sorts of issues impact everybody. We additionally have classes that we are teaching both at the undergraduate and graduate level on things like privacy engineering, where students actually learn how to write end-user license agreements and privacy policies and go through these sorts of things. So we are truly at the leading edge of not only security research, but we're trying to bring privacy into that, both from a research perspective as well as a teaching perspective. So go Jackets.
I would also add Professor Peter Swire is senior counsel to our firm.
Yes,
So
I think that's right.
Thank you. Final question, Representative Perkle has.
No, I'll ask offline. We're
Offline
good.
question. Super.
Mhm.
Well, everybody, thanks for being here today. We're going to wrap up here at I've got 11 after the hour. I'll distribute this to members of the committee.
Okay.
Get on your Delta app so they know you're coming.
Yes.
Members of the committee, I'd like to thank you for being here today. I know there's folks tuned in from the internet that's been watching this. This was a very informal discussion today. As we know, we're not taking action as a committee, but we wanted to catalyze this discussion because it does raise lots of questions. I think it's very important that we understand the existing legal framework that applies to Georgia, the framework that applies now in the EU, and other concepts what may be termed emerging frameworks in other states that would inform us to act or not act as is appropriate. So I just wanted to say to Mr. Harvey, thank you for being here with us today. And if there's some questions offline, we can take those. But with that, we stand adjourned.